Greetings, everyone. My name is Jonathan Bailey, and I'm from the site Plagiarism Today, which can be found at plagiarismtoday.com. And happy Monday, everyone. Hope everyone's enjoying a successful return to work this week. One company that is definitely getting to work this week is Oracle, who and has announced formally that they are going to appeal their recent ruling in the Oracle v. Google Java case. And all I have to say is, good luck with that. In all seriousness, this is to recap the case as quickly as I can. When Google developed a version of Java for the Android mobile operating system, Oracle stepped up and said that that version violated both copyrights and patents that they acquired when they bought Sun Microsystems. And as a result, they were suing for damages on both. The judge in the case, Judge Alsup, I believe his name was, broke the trial up into two parts, one for the copyright claims, one for the patent claims, and if there was a needed third part, there was going to be a damages section to it as well. The end result of it was the jury kind of returned a very split verdict on the issue of copyright, saying that that Google had violated several copyrights, especially in the APIs of Java, but that it was unable to return a ruling on fair use. So basically, had ruled there was infringement but couldn't rule if there should be damages awarded. Fast forward on to the patents case, the jury just kind of ixnayed and threw out all the patent claims. No big deal there. Um, but with the copyright claims, the judge came back after the fact and said that the APIs were not copyrightable, and therefore no copyright claim to be made, and the jury award was set aside on those. And I think there's still one alleged infringement of like 9 lines of code or something like that inside Java, and that'll be a maximum cap of $150,000. It's going to be limited to statutory damages, so there won't be a big deal. But the point to it all, and I do have a point to this, is that Oracle has now decided it's going to appeal that aforementioned ruling, which puts APIs and those APIs, at least in the non-copyrightable category. It didn't rule on APIs in general, just in those APIs. Very important point to make in future cases. Like I said, good luck with that. Judge Alsup, apparently, I did not know this at the time, but apparently has a background in computer programming, and a very solid one too. Actually, seems to be very knowledgeable in this area, and wrote what I read and what other experts have read to be a very well written, well thought out 41-page ruling on the topic. I didn't read the whole thing, admittedly, I skimmed it, but definitely a solid ruling, and it's going to be a tough one to overturn because when you appeal a ruling, it's not enough to say, I don't like this ruling. You have to say, what legal grounds do I have to overturn this case? And you've got to make it good enough for the appeals court to look at the lower court judge and go, you were wrong. And, because you were wrong, you've got to do it all over again. And so it's got to be not just legal grounds, it's got to be good. It's got to be something meaningful. And they're going to have a hard time assailing this decision. I think it's a very well thought out ruling. And another problem is appellate court judges, they do tend to be less savvy on these tech type of issues because they tend to be older and more further along in their careers for obvious reasons. That's how you get to be an appellate court judge. But they're aware of that, and when they're dealing with a lower court judge that is more savvy on a topic, they tend to trust that judge even more and tend to scrutinize any arguments against that judge even harder. So obviously Oracle's got the uphill battle. It's worth appealing, don't get me wrong. Oracle has every reason to appeal. The cost of appealing versus the potential rewards if they win easily make this worthwhile. It's going to cost them next to nothing in the big scheme of things to file the appeal and take the shot. So I don't blame them for appealing, but I just don't think they have a very high likelihood of success. Now, one thing an expert I did read online pointed out is that they do have one potential thing in their favor, and that is this is an issue of legal fact. A legal issue, rather, not an issue of fact. Boy, that was a screwed up sentence. But anyways, point being there, if you come up to an appeals court with a he said, she said situation where that you're trying to dispute the findings of the judge and the jury as far as what actually happened, that's a tough case to make. But if you've got a dispute over a legal fact, such as whether or not APIs are copyrightable, you've got a better shot. Because on the appeals court level, you have more room to negotiate, more room to sort of pitch your case of what the law should be, not what it is. And the appeals court has more room in which to go against other court rulings, especially district court rulings. So they do have that in their favor, but they've got a hell of a ruling to contend with, and they've got to find some pretty major holes pretty quickly. I think they're going to put up a good fight, but I don't think Oracle's going to win this one on the appeal. But do expect the appeal to come soon, and follow it closely. It's going to be interesting. And if you are involved in software development, watch this case and watch this appeal extremely close, because it could deeply impact what you do for a living. On that note, everyone, I'm going to cut out today because, like I said, it's Monday. I got to get to work. But in the meantime, this is Jonathan Bailey signing off.